Hey, everybody. Welcome. For any new viewers we might have, my name's Lori Hellis. I'm a retired criminal attorney, did both prosecution and defense, and I'm currently an author writing a book about the Vallow-Daybell case. I live in Boyce, Idaho, where I moved to cover the case, and we get together on Wednesdays to talk about all things true crime. And then on Fridays, we get together to talk specifically about the Vallow-Daybell case. So welcome, everybody. I'm going to just give everybody a couple of minutes to catch up. So before we get started, I wanted to talk about a couple things, just a couple of announcements. So first of all, because I think we need a palate cleanser, I want to introduce you to my grand cat. It's just a cute cat picture. But sometimes we do so much in true crime that we don't stop for a minute to think about fun things. I also want to point out that up over my shoulder here, up over my head, are our quilt squares. I'm going to tip up a little bit so you can see them, for our True Crime Quilt Guild. There's still time to get involved with our True Crime Quilt Guild. Here's the pattern we're working on. It's a sampler pattern. I have been posting how-to videos on the website, on YouTube. Let me get engaged here. I have been posting how-to videos on YouTube, on our YouTube channel. And there are also some links to a couple of other instructional videos or audios that were done by the pattern creator. So it's been great fun. We're down to the last two squares, which I will be posting the how-to video on, I hope, tomorrow. And then we'll have one more on how to assemble the quilt. And that should get us right to trial time. So it's been a great fun to do this quilt along while we were waiting for the trial to begin. One other, I've had a couple of folks ask me a question too about this book. Leah Tylee is an author. She is a freelance journalist who works out of the state of my home state, Oregon. And she's written a book about the Daybell-Vallow case. And a lot of people have asked me, in light of the fact that I'm also writing a book, what I think about this book. I think it's a great book. Her approach to the case and her interest in the case, it is different than mine, and our books will be very different. First of all, this book came out before the trials, obviously. So her slant on the case is much more, she's much more interested in the cult and the right-wing cult groups and how this case relates to them. So it's a very interesting book. It's very well written. I would say beautifully written. I think that we cover or will cover different ground. So I recommend it for anyone who's interested in the case. I didn't say that about a couple of other books that have come out pre-trial about the case and really were sort of just regurgitation of what was already out in the public domain. It was really just sort of a repeat of everything that you already know about the case because you could find it online. I didn't find that to be true, and with this book, and I liked the fact that she did make some interesting connections to many of the other sort of right-wing organizations that are out there. So I recommend it. There's room out there for all of us. And so I would encourage, if anybody is interested, that you might want to take a look at Leah's book. So we have a bunch of stuff to get to tonight. What I had intended to do was to start out our first hour. We're going to go 2 hours tonight. Hopefully you saw that in the listing. Our first hour, we're going to be talking about our usual true crime roundup, about some of the other cases that are going on in the country. And then we're going to take any questions that you have about those cases. The second hour, we're going to talk strictly about Vallow-Daybell, the upcoming trial, the hearing that was held today on some of the outstanding motions, and sort of what we can expect in the run-up to the trial. So I wanted to start with the Brian Kohberger case. Brian Kohberger is the defendant who is currently in custody in jail on the University of Idaho murders, the 4 students at University of Idaho and Moscow, Idaho, that were murdered. He is currently in custody and will very likely remain in custody until his trial. He is scheduled for a preliminary hearing on June 26th, I believe. For those of you who are a little confused about preliminary hearings, let me just say that in all states, in order for a felony to move forward to indictment, the facts have to be presented either to a grand jury or they have to be presented to a judge in a preliminary hearing. Those of you who follow the Daybell case, remember that Chad Daybell had a preliminary hearing on the initial charges having to do with the destruction of evidence. And in Idaho, typically cases go to preliminary hearing. It's unusual in Idaho for a case to be presented to a grand jury. However, when the Daybell-Vallow case was under investigation, the prosecution decided that they wanted to present to a grand jury rather than have a preliminary hearing because of the level of publicity, even at that point in the case. So the monkey wrench in the Vallow-Daybell case was the fact that we were in the middle of COVID and the courts were essentially shut down. What that meant was they had to wait until the court permitted them to convene a grand jury. And that took almost a year. In the Kohberger case, we're scheduled for a preliminary hearing. That's very typical of Idaho criminal cases. And going forward, I'm sure that we will see that presentation. I'm planning to attend. Hopefully I'll be able to bring you information from the courtroom, but we're running into the same problem that we have had with the Vallow case, and that is no cameras in the courtroom. The judge in that case, in the Kohberger case, has issued a gag order, and the gag order is incredibly broad. It basically says, you can't talk to nobody, no way, no how, if you've ever even heard of the case. It is breathtakingly broad. And I think because of that, it's likely going to face some constitutional challenges. We've seen already in the Kohberger case that a number of media outlets have filed suit in the Kohberger case and have filed a writ of mandamus and have filed a petition with the Idaho Supreme Court to have the Idaho Supreme Court decide whether or not this gag order is overly broad. Now, there is a difference between this and the Kohberger case and the Vallow case, because In the Vallow case, the court did issue a gag order. At least we understand he did, although we hear it's been sealed. But in addition, the judge determined that he was not going to permit any cameras in the courtroom. The difference is that under the Idaho statute, the judge has the final word on whether or not cameras or any sort of media access are going to be allowed. That it is not appealable to the Supreme Court. The Kohberger case is different because the media are challenging the gag order, and the gag order is appealable because it is an interim order. They're entitled to an interlocutory decision. So what that means is that because there is a court order that says I'm gagging everybody, and not a blanket decision from the court on cameras in the courtroom, there is leeway for the media to appeal the gag order. In the Vallow case, there is no recourse. I know this just makes everybody crazy. It makes me crazy, but it makes everybody crazy that there is no higher authority to appeal to in the Vallow case. The statute is very clear on its face that the authority rests solely with the trial court judge, and it is not an appealable decision. Until the unless and until the Idaho legislature decides to change that, that's where we're stuck. So next hour, we're going to talk a lot about court access and what that's going to look like. And I'm going to have lots of information for you, but I do want to get a little bit further into giving you some updates on the other cases that we're talking about. So one of the things that we've heard recently, and I hope this is old news to you, but it might not be, is that the landlord who owned the home that the murders took place in has decided to demolish the apartment and to donate the property to the university, hopefully for some sort of a memorial or some kind of a student focused property. So the other thing that's been going on is that in the Kohberger case, we have had this sudden release, this dump of all of the search warrants that law enforcement served on all of the different organizations and media companies and banks, and you could see what they were doing. Let's remember that they are looking for a needle in a haystack. And the bigger the haystack, the more likely it is that they're going to find something. So they went out and just blanketed everybody that they could think of that Kohberger might have been in touch with, might have talked with online, any of those organizations they've blanketed with search warrants. Does that mean that organization has information? No, it means they could. And if they do, they're required to produce it to the law enforcement. But it does not necessarily mean that they have information. For example, there were search warrants that went out to Walmart, and everybody jumped to the conclusion that he must have bought the knife at Walmart. Well, he might have, but he might not have. All they're asking is that if there is information, if Walmart has information that would indicate that he was there and made a purchase, they want to know about it. Likewise, Amazon and a knife company and a bunch of other potential retail outlets. Likewise for the banks. Nobody thinks that everybody was banking at all those banks, but we do know that some of them were banking at banks, and what people do with their money is often a good indication of what's going on in their lives. So it's always important for law enforcement to be thorough in making sure that they understand all of the banking transactions. So I just noticed in chat, and I want to just emphasize our mods are on top of it, but our chat moves fast and I talk fast. I'm going to open it up to questions having to do with these cases we're talking about now in about 10 or 15 minutes when I'm done with all my recap. If you would please hang on to your questions and post them when we ask for them, you have a much better chance of getting your question answered. If you've posted in the chat, if you've already posted in the chat, please repost when we ask for questions, because it's hard to catch up on those things. So a lot of people have been wondering why it took so long for some of those search warrants to be served. And a lot of people jumped to the conclusion that it was because law enforcement was somehow sitting on those warrants. That is not at all the case. But let's remember that we have a 14th Amendment to our Constitution, which means that states have sovereign rights. And so when law enforcement in Idaho is trying to get records from, say, Reddit in California, they actually have to, and it varies from state to state. The procedures vary from state to state. But what they actually have to do is they have to send that warrant to a California law enforcement agency. And that California law enforcement agency has to honor that warrant and serve the warrant. So in some states, it even requires a court order where the court orders the receiving local law enforcement to enforce the search warrant. So enforcing a search warrant outside of your state jurisdiction is not a simple thing. It is made more simple when you have organizations such as Walmart, for example, because they do business here. And so it's easier to serve a search warrant on Walmart because you can do it in the location where they're doing business. But in an online market, such as Amazon, or in an organization where an online social media organization where the headquarters is outside of the jurisdiction, it's going to take a few more hoops to jump through in order to get those served. So I have no reason to believe that law enforcement was sitting on those warrants, but it is more complicated when you are serving out of your jurisdiction warrants. So I know that we have a few new followers. Thanks in part to the fact that Gigi and I were on Surviving the Survivor YouTube channel last week, or earlier this week, actually, Monday. And we had a great experience. We had a fabulous discussion about the Vallow-Daybell case. I have linked the site to the, you'd think I could unwind my tongue. I have put the link in our show notes today. So if you would like to go and watch that, please do. But because we have we've gotten a little bit of extra attention thanks to that appearance, I think we may have a number of new viewers. So if you are a new viewer, welcome. And if you would like, please consider subscribing. Here's the reason. I will be faithfully attending the trial here in Boise. I moved here in order to be able to cover this trial. I will be faithfully attending. And I will be tweeting out. I will be doing YouTube shorts. I will be trying my very best to keep everyone advised of what's going on in the courtroom, because the only other way you're going to get that information is through the released audio at the end of every day. So please consider subscribing. Please consider hitting the notification bell so you'll have notifications when we go live once the trial starts. For right now, our lives are scheduled Wednesday and Friday, 6 Pacific. But that is going to change once the trial starts. We talked at length about the Murdaugh trial, and a lot of you were following Murdaugh and have gotten hooked on true crime thanks to Gigi following and Pretty Lies and Alibis following the Murdaugh trial. And a lot of you have gotten hooked on true crime. And now here we're off to the races. In early April, we have both Letitia Stout and Lori Vallow going to trial. So there are a few sort of loose ends being tied up about the Murdaugh case. One of the things that's sort of interesting is that when Alec Murdaugh was involved in stealing money from his clients, one of the people who was I don't know, I don't think Murdaugh was indicted as a co-defendant, but was involved was the president of Palmetto State Bank, Russell Lafitte. He and Alec were good friends and kind of helped each other out and perhaps helped themselves to some of the money that belonged to Alec's clients and was in trust with Palmetto State Bank. Russell Lafitte was tried on federal bank charges, found guilty, but he had yet to be sentenced. And one of the reasons he was not sentenced was because they really wanted to hear what was going to happen in the Murdaugh murder case. And now Russell Lafitte is asking for a new trial because Alec Murdaugh supposedly got on the stand and said Russell Lafitte didn't have anything to do with it. He didn't steal anything. It was all me. How believable that's going to be in light of all of his history of lying is questionable. And I don't expect that the court is going to give Russell Lafitte a new trial. He is due to be sentenced shortly, and I expect that sentencing will go ahead. Billy Wagner, if you remember the Wagner murder trial, Billy Wagner was back in jail, was back in court again for a pretrial hearing. Those of you who followed that trial, the Wagners were a family, kind of lived in a family compound, and they were found, the mother and one son pled guilty and agreed to testify against the second son and the father, Billy. Son George was convicted of murder, and Billy's case is the only one still outstanding. There was a new judge appointed on the case. The judge said he would consider a possible change of venue, and there is no new trial date yet. So still in the preliminary pretrial phase for Billy Wagner. A lot of you are anxiously following the Dylan Rounds case. As you know, Dylan was a 19-year-old young man who was dry farming in Utah when he disappeared. He's been missing now the better part of a year, and his parents have been faithfully looking for him ever since. A week or so ago, information was released in the probable cause affidavit for the arrest of the person who's been accused of his murder, but his body has not yet been found. His mom and dad have been giving interviews, and in their interviews, they say that they are still committed to making sure that his body is found and that they will be out in earnest searching soon. One of the issues is that it is an area that is, like Rexburg was, snowed in and frozen. And like the Vallow case, where they had to wait for the thaw to find the kids' bodies, they've had to wait for the weather to improve in order to find and in order to do an effective search for Dylan's remains. I want to remind everybody that I have the world's best moderators and that they are on it. And I appreciate them more than I can say. So as always, all of our super chats that you send us, your generous donations go directly to our mods. And that's just my way of saying thank you. I also want to thank everybody who's bought me a coffee this week. Somebody asked me why I didn't have a link where people could buy me a coffee. So I did it. And I'm here to tell you I am a coffee girl. And so y'all buying me a coffee has been much appreciated. I think I'm set for coffee at least until the trial starts. So thanks. So I think we're ready to take some of your questions about the cases we've been talking about. Now, I have a whole bunch to say about Vallow-Daybell, and we're going to get to that with a vengeance in just a few minutes. But let's start with your questions about the cases we've been talking about so far. Hi, Sun Valley Esquire. Oh, I'm actually having an old fashioned tonight. Sounded good. Question: in the Murdaugh case, what do you make of the news that South Carolina has statute that precludes the state from using any disclosures from Alex's trial testimony against him in the financial crime trials? Well, there may be some protection. I'm not a South Carolina lawyer. This makes me a little curious, and I will look into that further because I think I'm making myself a note. Because I think that it would be very curious. In most cases, the judge is required to advise the person testifying that anything they say can be used against them. And I think Judge Newman did that. So I'll look into that because I would be surprised if, understanding that what he was saying was sworn testimony, that it wouldn't be able to be used against him. So I'm gonna look into that and expect an answer next Wednesday, because that is an interesting question. Don Schaefer, any update on a GoFundMe for the Daybell transcripts? There is. I had a discussion with several creators about that. One creator just said, you don't need a GoFundMe, I'll just pay for them. And then we found out that Nate Eaton and East Idaho News have already decided that they will get the recordings daily and will post them on their website and their YouTube channel daily. So it meant that it wasn't necessary to do a GoFundMe for the audios. There are transcripts there may be transcripts created of the trial. Let's put it that way. They're often very rough. You might have seen that if you watch the Murdaugh case and how difficult it was to get transcripts, because let's remember that we actually have to have a human being who's listening and transcribing the proceedings. And that's a pretty labor-intensive job. if someone orders a transcript for the purpose of an appeal, that sometimes takes months because it takes so much time to check and recheck and make sure that the transcripts are accurate before they're certified by the producer. So I don't suspect that we will get transcripts, but the recordings of each day's proceedings will be released as soon as they're available through East Idaho News. I expect that there'll be other creators who will want to get them themselves, but for the general public, I think that it is incredibly important that the public is aware and has the access to be able to oversee the operation of their government, because we're a government of the people, by the people, and for the people. And that means us, the people, get to look over the shoulder of our government employees, and particularly our elected officials, and assure that they're doing a good job. And for anybody who read my newsletter today, I have a lot to say about that, and particularly in the Vallow case when it comes to how the prosecution has conducted themselves. So we'll be talking about that in a little while, but for now, we're not going to be doing the GoFundMe because we don't need to. It was very generous of East Idaho News and Nate Eaton to step up and say, we're a news organization. Now, they have been deeply and intimately involved in this case since day one, because they are really the folks who are on the ground. And so I am happy to report that they have been very generously have offered to make those available to the public. So, but I want to thank everybody who was absolutely willing to pull out their checkbook and say, let me donate, because this isn't right, and we need, the public needs to have access to it. So kudos to all of our true crime community who understood how incredibly important that is. The Reels 360. So what do I think about the Petito Schmitz suing the laundries? You know, I think that we have to ask ourselves how responsible one individual is for the conduct of another, even if it's a family member and even if it is your child. And when does that responsibility end? Now, it's my understanding, and I'm not an expert on the Petito case, but it's my understanding that the Petitos at least have some evidence and believe that the laundries were responsible for covering up what they knew about Gabby Petito's death. And that is sort of a different analysis than saying you parents are responsible for the conduct of your adult child. I don't believe that we as a society should be jumping to that conclusion. I even question whether as a society we should be jumping to the conclusion that if you are a school shooter, your parents were responsible, and you are a minor, your parents are responsible for your conduct. That's a different sort of analysis. But I think in the Petito case, what Gabby's family has said is that the laundries knew that it was likely that Gabby was dead, or knew that she was dead, and that Brian was responsible for her death, and that they withheld that information from the Petito family, and caused them great anguish and great uncertainty, and that in the aftermath, they helped Brian cover up the fact that he had been responsible for her death. And I think that's a different analysis, and I actually think they have a point. Had Brian and his family come forward, and particularly had his parents come forward, they would not have had the horrible emotional anguish of not knowing the fate of their child and of not knowing where her remains could be found. So I think that they may prevail on that intentional infliction of emotional distress, because I think the Petitos are going to experience lifelong that anguish of not knowing. That's a great question. And I love that we have the opportunity to talk about these things and answer these questions on Wednesday night. Hi, Kathleen, my faithful supporter. Do I know what the misdemeanor warrant was for Alec Murdaugh? I do. And it's interesting. You may have noticed in the trial that someone from Murdaugh's family passed him a book at trial. Now, Alec had been advised that he was not to be able to accept anything handed to him, that it was not going to happen. And somebody from his family handed him a book. Now, we don't know if it was just a book he wanted to read, they wanted him to read, whether there were notes in it. No, nobody knows. But it's like the bar, right? In the courtroom where the lawyers and the defendant are in front of and the gallery is behind. It should be treated like a wall, an impenetrable wall. So breaching that and handing him a book was considered introducing contraband. He was being given contraband, and he accepted it, and that meant that they charged him with a misdemeanor for that. And that misdemeanor warrant was served on him while he was in the courtroom. I don't know that it was all that necessary, but maybe it was to make a statement to the public that the Murdaughs are not above the law, that they have to comply with the law just like everybody else does. So it was kind of an interesting little twist to the Murdaugh case. Good question. Thank you, Kathleen. Hi, Janet. Along the same lines, what are your thoughts about Ethan Crumbley's parents' charges? This one is kind of thorny, and I can see both sides of it. On one side, our legal system typically says we're not going to make an individual be responsible for the actions of someone else. You can only control and be responsible for your own actions, which is why we have statutes that people can be held responsible for being accomplices to a crime or conspiring to commit a crime. But we don't have statutes that say, you weren't a good parent, you didn't raise your kid right, and now your kid did something horrible and you're responsible for that. And I think that is the line of reasoning that the state is going forward with in the Crumbley case. What makes it complicated is the fact that the parents knew, and this gets more to not an argument that you were a bad parent, but an argument that you were negligent, and and that you allowed this to happen because they knew that he was struggling. They knew that he was having some emotional problems. They bought him a gun. They gave him access to ammunition. When they were called into school because the school was concerned about some of his writings and drawings, they shrugged it off, didn't check in his backpack to find out whether or not he'd brought the gun to school, didn't take him out of school, in fact, insisted that he remain in school, mostly because they were busy and had to get back to work. And so it's kind of a fine line, because I think the state is proceeding on the idea that they were negligent, and their negligence contributed to the school shooting. I don't know how far this goes. It is going to depend on some really technical arguments, and I think it's going to go well up to the Supreme Court, because juveniles are treated differently. We say kids are different, and I don't know if that means that kids' parents are different. But it's a case I'm watching with a lot of interest, because it could have some major impact on how we prosecute cases having to do with kids in the future. And I understand that part of this is that he was a school shooter, and that we have had this incredible epidemic of school shootings. And I think as a society and as a government, I think we're grappling with how to get our arms around that, how to keep that from happening. And it just keeps happening. And so perhaps this is a reaction to the fact that we all feel awfully powerless when it comes to how to cope with these school shootings. I'm not exactly sure that this is the right way to go about it, but I think that we're all hoping that solutions are going to come, and that we're going to see a change in the way that we're approaching these kinds of cases, so that hopefully we're preventing school shootings rather than just reacting to them. And I understand it's a social frustration. Sue L. How does the Crumley parent charge compare to Alex's culpability for the boat crash with Paul? Oh, good question. So I think that, first of all, we have to make the distinction that the Crumleys are being charged criminally with the failure to supervise their child, and therefore they're responsible for the deaths of these people. They're actually criminally charged with negligent homicide. In the Murdaugh case, Alec was sued civilly for culpability for the boat crash. And there's there's actually a lot different standard when it comes to civil versus criminal. So the Crumleys are being prosecuted criminally, but Alec Murdaugh was sued civilly, and the theory was that he was at least partially responsible because he provided the boat and gave Paul access to the boat. The boat belonged to Alec. There's also some evidence that they were very permissive when it came to the use of alcohol, and that they may have known that Paul had Buster's driver's license and was using it to obtain alcohol. So it's from a legal standpoint, it's two very different things, because one's civil and one's criminal. And I think if people from the school shooting had sued the Crumbleys and said, you're responsible for the death of our children in a wrongful death suit because you provided the gun and you provided that, we would be having a different conversation. But the question is whether parents can be held criminally liable for the actions of their kids. So that's a great question though, Sue. Thanks. Thug Nasty. Would it have made more sense to charge the Crumbly parents with felony murder? Child abuse by way of mental harm is a felony here in Michigan. So by ignoring him would make them a party to the crime. That's an interesting legal theory. Child abuse by way of mental harm. I guess that would probably, you would have to look at really whether or not that has a real specific definition or not. Because in some cases, there's a very specific definition of how you get to mental harm. At least in my experience, when you're talking about emotional abuse of a child, it has kind of a specific definition. It may be that their actions didn't really fall within that mental harm definition. Certainly, they were negligent parents. There's no argument about that. The question is whether that negligence rises to the level of criminal prosecution. But it's an interesting question, and I guess since I don't practice in Michigan, I don't know that what the legislature intended to define child abuse by mental harm. But I think it would be certainly something worth looking into. And it sounds to me like maybe some folks in the media are suggesting that in Michigan. Hello, Barb. Question. Hi, Lori. I'm curious about the dynamics of the Murdaugh family. Alec and his 3 siblings. Do you have any thoughts about Alec and his role in the family dynamics? For example, who was the golden child? Well, I think it's pretty clear that Alec was pretty much the golden child. I think that's clear by some of the comments that his brother Randy made. And I think it's clear by the actions of his siblings. His siblings, all John Marvin and his sister Lynn, being there every day at the trial, being there with Buster. I think that suggests that he was sort of the patriarch's golden boy. I also think that over the years, we have ample evidence that he looked to his father Randolph to get for bailouts, whether it was financial or whether it was my kids are in trouble. Everybody looked to Grandpa Randolph for a bailout. And I think that was especially true for Alec. So I think I think the family likely would say that he's the golden child. Now, Randy has made some statements recently. We have to remember that he is a lawyer and he is trying very, very hard in the face of this terrible smirch to his family name, to try and recover his reputation as a lawyer, and hopefully preserve that going forward. So it's hard to say what his motivation is in coming out and saying, I had my suspicions, but he also was the brother who was there to confront Alec from the law firm about the theft. So I think it's safe to say that Alec was what was sort of the favorite, and that he had been conditioned to look to Dad to bail him out, and Dad has been bailing him out for a long time. There's a lot of anecdotal information out there in social media about the Murdaughs, and particularly about Alec. People posting things, their experiences interacting with Alec and Maggie, with Alec and Paul, and it's pretty interesting. There's a lot of at least anecdotal evidence that Alec was aggressive. He was kind of the same sort of angry, belligerent drunk that Paul was, and that he had gotten into his own a fair amount of his own trouble in college and law school. So I think there's enough out there to suggest that he probably needed the same rescue from Randolph that Paul later needed, and it's clear that they. I mean, one of Paul's girlfriend talks about how Paul was drunk and driving erratically and rolled his truck, and Maggie and the family all showed up there to unload all the guns and the alcohol out of the car to make sure that it was all gone by the time the police arrived. And so there was certainly this dynamic of Alec being above the law and Randolph bailing him out when he got in trouble. That's the reason why Paul immediately called his grandfather after the boat wreck. The first person he called was Randolph, his grandfather, because his grandpa was the fixer. Any more non-Vallow questions? Because I have plenty to talk about when it comes to Vallow. Okay, on your mark, get set, Vallow. Oh, one thing I did want to point out, I'm looking at my notes here. Nate Eaton and several other news agencies had asked the court to set aside a seat in the courtroom every day for a pool sketch artist because no photos. And the judge granted that request. So there will be a sketch artist in the courtroom, and I'm certain that we will see lots of sketches come out of that. So that was good news. Also, I want to point out that I have a bet with Zelda, a pound of Starbucks coffee on whether or not Lori takes the stand. She thinks that Lori will take the stand. I think she's going to follow her lawyer's advice and stay off the stand, but we'll see. And I wanted to talk a little bit about court access. I outlined this in today's newsletter, but I also want to talk a little bit about it. As I said earlier, the decision on whether or not to allow live stream, whether to allow cameras, whether to allow photographs is purely, strictly, and absolutely with the trial court judge. So Judge Boyce gets to make that decision, and there is no higher authority to appeal that to. So what we know right now is that there are somewhere around 250 seats available in Ada County in Boise for the trial. Those seats are divided up into about 70 to 75 places in the courtroom and the rest in an overflow courtroom. So what the judge has ordered at this point is that there will be a closed circuit video feed that will go from the courtroom where the trial is taking place to an overflow courtroom in or an overflow viewing area in the Ada County Courthouse. So that gives folks who may not have been able to get into the courtroom still get access to the trial. Additionally, the court has ordered that there be a closed circuit link to Madison County, to the Madison County Courthouse, where people from Fremont and Madison counties can go to watch the trial. Other than that, there is no access. That video feed will not be recorded or stored in any way. And so once it is transmitted, it is gone. There's no way to access that later. The only recorded access will be an audio feed, and that will only be available after that day of trial. So let's say Monday is a day of trial. Those people who want to get into the courtroom have to go on the court's website at 8 a.m. on Friday, the business day before they want to be in the courtroom, and put their name in for a reservation. If they are not able to get into the courtroom or the overflow, the next alternative will be to listen to the audio the afternoon after the trial closes. So Monday's trial coverage, Monday's trial audio will be available Monday late afternoon, early evening. So if you want to listen to the audio, that will be posted on East Idaho News's YouTube channel as well as their website. Now, I've posted links to all of these things in today's newsletter. So go find those if you're at all interested in attending the trial, because you have to make your reservation at 8 a.m. on the day prior to the day that you want to attend. For those of us who are planning to attend every day, it means making sure that we're online in the ticket queue at 8 a.m. to be able to get into the courtroom. The court held on Monday, an informational meeting for media. Lots of familiar faces were there. It was a Zoom call, lots of familiar names. And so they answered a lot of questions about the logistics of how things are going to work. March 27th and 28th, the jurors will be asked to come to the courthouse and return their jury questionnaires. So potential jurors who got a summons also got a jury questionnaire. And they're being asked to return those jury questionnaires on the 27th and the 28th. Jury selection will begin on April 3rd. There will be no seats in the actual courtroom during jury selection. This is in order to protect the personal information of the potential jurors. So people who want to attend jury selection will be seated in the overflow area, and the court will have the ability then to mute certain parts of the juror interviews. The plan is for the jurors to be questioned in small groups with the ability for the prosecution or the defense to pull out jurors and question them individually about more personal matters. One of the things that both sides are going to be very interested in, of course, is religious affiliation and the people's involvement or non-involvement in religion in general, and specifically in the LDS Church. So we know that's going to happen. Once the jury is seated, and we don't know when that will be, it could take 2 days, it could take 10 days to seat the jury. Once the jury is seated, then once opening statements begin, people will be permitted into the courtroom proper. Like with the Murdaugh trial, I think you're going to see a lot of a lot of effort to preserve the privacy of the jurors, as well the court should do. And I think we're going to see opening statements, and then the prosecution's initial witnesses follow on very quickly once the jury is seated. We don't know when that will be. As the jury selection goes along, we'll get a better picture of that. So I agree that it is incredibly frustrating that this case is not being live streamed. I can see absolutely no reason for it. I could understand the reason why the court decided not to allow live streaming for the pretrial. But once the jury is seated, then there isn't likelihood that the jury is going to be influenced by the live stream coverage. So it's unfortunate that the judge has taken this position. However, it's what we're stuck with. So know that I'll be in the courtroom tweeting, sending out live stream YouTube shorts, doing as much as I can to get information out about what's going on in the courtroom. I know other creators are committed to doing that as well. Gigi McKelvey from Pretty Lies and Alibis is going to be there for Law and Crime Network. She's going to be tweeting out. I know Nate Eaton's going to be there. And I'm sure there are going to be many other creators that are going to be dropping in and out during the trial. So I think we're all committed to making sure that the public has as much access as we possibly can get you. Along that line, we've seen that Nate Eaton and Anjanette Levy from Law and Crime Network have both filed requests with the court to live stream the trial. Both of those requests have been denied. I think that's because they're hoping to set up some sort of a motion to intervene and some sort of an argument to be made to the court about the possibility of streaming it. I'm not convinced that the judge has really answered the concerns of the families who are not going to be able to spend 8 to 10 weeks that the judge still thinks this case is going to take to be here. I think that is very difficult. It's a true miscarriage of justice for some of the family members, the Vallow family members down in Louisiana, the Cox family members in Arizona or Utah. I'm not sure where they are. Many of Daybell's family are all in the Rexburg area, and his parents are in Utah. I mean, it's very difficult to see how it's fair that they're being denied access. Somebody asked me whether or not the court was going to be setting aside seats for the family or whether they had to go through the reservation process. I'm certain that those seats will be set aside for the family, that Kay and Larry are not going to have to get on the reservation queue every day. So I expect that's going to happen. I think the judge felt like he was going as far as he was willing to by doing the live feed into Madison County as a way that anybody in that local area can at least go to the courthouse and watch the trial. But it will be interesting to see whether or not there is upcoming filings. There are going to be upcoming filings from the media having to do with being able to have access. So, we had a hearing today, and in that hearing, there were a couple of motions that were heard. Judge Boyce heard motions, states a motion to compel discovery, the state's a motion in limine and also a motion by the defense to take the death penalty off the table. That is a really tricky and I think important, potentially important motion. So just to back up a little bit, because we've gone round and round, I want to remind everyone that John Pryor was asking for discovery and complaining that he had not gotten sufficient discovery for 3 years. 2 years ago, he was complaining that he did not have FBI interviews, that he did not have. Understand that there's a difference between getting a report, which is essentially a recap of what an interview, and actually getting a recording of the interview. So John Pryor has been asking for those FBI, the interviews that were done by the FBI for at least 2 years. And for 2 years, the state has said, well, we gave you the reports. And Pryor kept saying, I want the interviews. The interviews were provided last week. And there are hundreds of hours of interviews. In addition, the defense has been asking the prosecution for jail calls and visits and recordings, and the prosecution said, oh yeah, we'll get that to you by July of 2021. They were never provided. Last week, they dumped 3,000 jail calls. I thought it was interesting that Jim Archibald made the point at this morning's hearing that for months, years, every time they would talk to Lori Vallow, she would say, well, what does Chad think about this? What does Chad know about this? And as Archibald said, we kept telling her, we don't know because he's not talking. He was talking. In 3,000 jail calls, he was talking. None of them were in the possession of the defense because the prosecution overlooked providing them. So they promised them in July of 2021, but they were never produced. And so when somebody asked them about it, they'd say, oh, we'll get you those two. We'll get those to you, or we already gave them to you. So I want to be really clear. Nobody in the world wants Lori Vallow to get a fair trial more than I do. I believe to my core that our system, our criminal justice system, works. But it only works when everybody plays by the rules and when everybody does their job. I have tried really hard to give the prosecution the benefit of the doubt because they keep talking about all this voluminous discovery information. Today, Lindsay Blake said, there's so much discovery that none of the prosecutors have actually reviewed all of it. Okay. So I keep hearing, well, if Lori would just waive her right to a speedy trial, this wouldn't be a problem. True. I don't think there's anybody out there who would more like to see Lori waive her right to a speedy trial than Jim Archibald and John Thomas. But she has not. The prosecution has a legal obligation to be ready to go to trial within the statutory 6-month time frame. That is their obligation. They have a legal obligation to turn over every piece of discovery to the defense in time for the defense to be able to use that information, or at a minimum, at least review it. Something that the prosecution just doesn't get. And it makes my blood boil. They don't get that it is not up to them to decide whether that evidence is good, bad, indifferent, inculpable, inculpatory, exculpatory, relevant. They don't get to make that choice. And this is something John Pryor has been saying for years. It's not up to the prosecution to decide whether this information is going to be useful or when I get it. Their job is to hand it all over and quit arguing about it. But at every step in this prosecution, they have obstructed and slowed down and slow walked discovery. And there is no way around it. Here we are. What are we? What did I say? 17 days from trial? And they've provided so much new discovery that even if they worked around the clock until trial starts, they still couldn't review it all. So the prosecution says, well, we've been through a lot of it and we've flagged stuff that we think is important. Once again, that's not the prerogative of the prosecution. That is the defense's job to review that discovery and determine whether or not it is relevant, whether or not it's important, whether or not it's exculpatory. Those aren't decisions the prosecution gets to make. And it is like talking to a wall every time the prosecution is reminded that they don't get to make that choice, that there are two sides to this case, and that it is the defense's responsibility and obligation to zealously represent their client. How can they do that if the prosecution is either intentionally or through their utter negligence withholding discovery? So I have a real problem with that. Today's discussion before the court, I think, telegraphed that Judge Boyce is having a real problem with it as well. Now, I've said for a while that the prosecution has spent $3.6 million on this case, and it has not even yet gone to trial. Why, in all of that expense, didn't they hire an experienced discovery clerk? Somebody who understands how to put together, organize, categorize all of this evidence, and who knows how to go back to the agencies and make sure that they have turned everything over. I don't know why they didn't do that, other than the fact that it is utter inexperience and hubris that has kept them on this case when there were other avenues and other opportunities for this case to be appropriately and correctly prosecuted. So if this case ends up, if Lori Vallow gets a new trial, or if this case ends up being overturned on appeal, it is firmly on the shoulders of the prosecution for these discovery violations. Now, one of the things that Jim Archibald asked for was that the court dismiss the death penalty notice for Lori because of all these discovery violations, because of the fact that the mitigation specialist, who is a very experienced and good mitigation specialist, said, there's no way I can go through all of this information and be assured that our client has gotten the best mitigation defense that I can provide. So if Lori is convicted and the death penalty is on the table in the sentencing phase, the mitigation specialist is saying, I'm operating with one hand tied behind my back. It's interesting that in today's hearing, Lindsay Blake did her usual, oh, there's no harm, no foul. It's not that big a deal. It's not that important, and tried to downplay it. It was interesting that the judge on his own, after having read all of their motions, asked Lindsay Blake, what about this federal line of cases that says that dismissing the death penalty is an appropriate response to discovery violations? And she didn't have an answer except to but. What was interesting about that was that it was Judge Boyce on his own doing the research and asking the prosecution about it. That telegraphs to me that he sees dismissing the death penalty as a viable response to this discovery dispute, to this, it's not a dispute, to these discovery violations. So that made me go, gee whiz. And I'm going to be very interested. The judge took all of these motions under advisement and said that he would issue either a written or a verbal decision on the 22nd. That's cutting it pretty close, but still, I think it's interesting. Lindsay Blake keeps saying, well, the bulk of the discovery was turned over. And then in her response to their motion to compel discovery, she says the defendant who keeps bringing up the bulk of the discovery having been turned over, they're intentionally mischaracterizing it. I don't think they are. I think they're spot on in saying you don't get a pass for just turning over the bulk of the discovery. You got to turn it all over. Some of the things that I found notable that I highlighted when I was reading these motions, the state indicated there may be additional video jail call and jail visits because it's ongoing. At some point, the jail, at some point there are going to be other jail calls and jail visits that are going to have to be turned over. But I thought it was interesting that it said the state provided the details of any calls and any in-person visits which were reviewed and determined to contain inculpatory or exculpatory information. Once again, the prosecution doesn't get to make that determination. It is not, they are not the gatekeeper. And Lindsay Blake just does not seem to understand that it is not her prerogative to decide which discovery is relevant and which is not. So she contends that the defense has failed to establish any prejudice by receiving the discovery late. So Jim Archibald filed an affidavit from their mitigation specialist, specifically talking about the prejudice that could flow from the fact that they are getting all this discovery late. One of the things that has come up over and over again in this case, because of Lori's prior mental commitment, is whether or not mental illness is going to be introduced into evidence at the guilt and innocence phase. Now we know that mental illness is a fertile ground. Excuse me, I have to adjust. Mental illness is fertile ground in the penalty phase. But the defense has already filed a notice saying that they don't intend to use mental illness as a way to negate any element of the crime. But the defense is really nervous. And here's the reason why. The defense is really nervous because they want to bring up Lori's religious hyper-religiosity. Okay. They want to bring that up as part of and parcel of the motivation for her committing these murders. But they're very worried that if they do that, the defense is going to say, oh, well, you opened the door and now we get to bring in all of this mental health evidence. So the prosecution, in trying to be prepared for that happenstance, has Dr. Michael Wellner in the wings. Now, for those of you who aren't familiar with Dr. Wellner, his CV is like 50 pages long because he's published so much and he's a member of so many organizations and committees. And anyway, Dr. Wellner is a forensic psychiatrist, so he's an MD, and his specialty is in evaluating competency and in mental health cases, including cases that have an element of hyper-religiosity. Dr. Wellner was the psychiatrist who spent many hours with Brian David Mitchell, Elizabeth Smart's kidnapper, before determining that he had been malingering. He has a tremendous background. And so the state has been hoping to keep him sort of in the wings should this come up. I'm trying to read my notes. They want to be able to call Dr. Wellner to talk to refute any of that the defense may bring up about her hyper-religiosity. So the state has repeatedly said that they don't intend to call Dr. Wellner, but here's what they say. Contrary to the defendant's claim, the state does not intend to call Dr. Wellner in the guilt phase. That position would only change if the door is opened by the defense calling into question the defendant's mental health as it relates to the state's burden to meet every element of the crime. Assuming the defendant's position remains the same as at trial, the state will not be calling Dr. Wellner, so long as the defense does not open the door through cross-examination or presentation of a mental health defense. So this is where it gets a little sticky. We don't know how this is going to develop at trial because there is this issue of when do religious beliefs become religious delusions? When do they tip over into a diagnosable mental health condition called religious delusions? So it's going to be very interesting to see how this plays out. The other thing that is somewhat interesting is the fact that Dr. Wellner has done a lot of, has published a great deal about the issue of evil and what the law calls depravity or a depraved heart, depravity. So Dr. Wellner has been writing about things like distinguishing everyday evil toward a clinical inventory of extreme and outrageous behavior. The word evil and depravity comes up a lot in his published writing. But he specifically, now I want to point out that in Dr. Wellner's affidavit, he is quick to point out that he has never evaluated Lori. She would never agree to have him evaluate her. He has repeatedly said that the things that he can testify to are general observations about mental health, but he cannot make specific diagnosis because he's never He's never interviewed her or never met her. But he says, I'm prepared to testify at either the guilt or the sentencing proceeding about the following: the Daybell Vallow group and its commonality with other LDS splinter groups, the impact of charisma, persuasive confidence, malignant narcissism, and other psychologically salient qualities among sect leaders such as Lori Vallow in dysfunctional splinter LDS groups. The role of homicidal destructiveness in pruning and cultivating splinter sects and its relevance to Lori Vallow. The challenges of attributing idiosyncratic religious thinking among LDS splinter leaders to psychiatric illness, given the culture of Latter-day Saint prophecy and how that distinction is to be made in assessments of examinees such as Lori Vallow. So that gets to, when does religious belief become religious delusion or hyper-religiosity? The available evidence demonstrates Ms. Vallow's contrived use of religion to control and direct others and to eliminate responsibilities impeding her transition to a new life. That's interesting. Ms. Vallow's actions and choices during the period preceding, during, and following the homicides reflect intact capacity to form criminal intent and an appreciation of the wrong of the murders. Ms. Vallow's involvement in multiple homicides reflects the influence of criminal deviance and personality, such as callous behavior and attitudes, rather than religious directive and the evidence in informing that conclusion. Ms. Vallow's involvement in multiple homicides reflects the influence of criminal deviance and personality rather than the influence of a major psychiatric illness and the basis for that opinion. The evidence demonstrates that the dynamic of Chad Daybell and Lori Vallow was one in which both manipulated each other. The more definitive diagnostic assessment of Lori Vallow at the time of the charged offenses would be undertaken once I have the opportunity to examine her, which I have requested. To date, she has declined to be interviewed by Dr. Wellner. So, to be honest, I think that Dr. Wellner's general knowledge may be interesting, but I'm not sure how much relevance it has to this case if he has not examined her, which she has declined. So there's a lot going on in this case. There's a lot of moving parts, a lot of it having to do with the issue of discovery, a lot of it having to do with whether or not evidence is going to come in at trial based on the late disclosures. So it will be really interesting to see what the judge is going to do with that. As I say, it seems to me that in today's hearing, he was telegraphing that he had an interest in the cases, the line of cases that would justify dismissing the death penalty. So that's going to be really interesting to see. I think there's a chance he may dismiss the death penalty as to Lori. I think that it, once again, is that rock and hard place because she has not waived her right to a speedy trial. And we know the volumes of discovery. We know that the prosecution has been at least sloppy in the way that they've provided discovery. we know that that puts Lori Vallow at a disadvantage. Now, if all of us want to see her have a fair trial and want to see our criminal justice system work, we want her to have the best opportunity to answer the evidence against her and to exercise her constitutional right to confront the evidence and the witnesses against her. Does that mean that she's not guilty, or does that mean that we're pro-defense? Not necessarily. What we want is for her to have a fair and complete trial and for the outcome to be defensible. If the process hasn't been followed and the rules aren't followed and she has not received due process, then the outcome can be challenged endlessly. So for those who really want to see Lori Vallow convicted, you should be the first ones to stand up and say, what the hell? What's going on with the prosecution? Because they're not fulfilling their constitutional obligations in a way that assures that she's receiving due process. And we all want to see that. There's a number of reasons why that's important. Most importantly, we want Lori Vallow, who may very well be very guilty, we want her rights protected, as well as every defendant's rights protected, because there may come a day that there are charges against me, and I want to be sure that the system will work for me. And the only way I can assure that is to be sure that the system works for everybody. So I think that as this case unfolds, we're getting close to the 22nd. That's next week when the judge will make a determination on these motions. We are literally days away from trial. And I'm going to be there to make sure that y'all know what's going on. Okay, I've said my piece and I've been on my soapbox, and it's time for your questions. Hi, Kathleen. If no death penalty for Lori Vallow, then would she be able to apply for parole? Oh, let's get back to that question, to Kathleen's question. Would she be able to apply for parole after, say, 10 years, or could she still get life without parole? She could still get life without parole. If the judge decides to take the death penalty off the table, I believe that she would still get life without parole. In Idaho, the rule is that you have to have asked for the death penalty before the penalty jury could determine life without parole instead of death. But I do believe that they would continue to impose life without parole. At a minimum, she would not be eligible for parole for 25 years, and we still haven't dealt with the Arizona cases yet. If Kay and Larry are called as witnesses as they should, would that mean they can't watch as victims until after their testimony? That's a good question, because Judge Boyce did exclude witnesses. There is a victim Bill of Rights, and that Bill of Rights includes being able to attend the trial. So I don't believe that the exclusion of witnesses would apply to Kay and Larry. I'm pretty sure they will be able to be in the courtroom. And to be honest, I'm not sure that it's necessary to even call them as witnesses. The state may want to do that only because they're very sympathetic, but I'm not sure it's really necessary, because all of the information that Kay and Larry would testify to are things that law enforcement can testify to. We already got Kathleen's question, so let's move on to the next one. Hazelnut, how in the world could anyone ever make the statements about Lori Vallow and her family that Dr. Wellner has made? Is it even legal? Is it ethical? I think it's concerning that he's making generalized statements when this is someone he has not examined. And I think that it violates the psychiatrist, the medical profession's code of ethics. I think that he could go and testify about, in general, what people who are hyper religious do, or he could go and testify about his experience in working with LDS splinter groups. He could not specifically make statements about Lori Vallow and her family because he has not examined her. And I agree, I don't think that's ethical. Bonnie Tipton, why is she fighting the death penalty? Doesn't she want to be safe and happy like JJ? If she believed in any of the nonsense, she would plead guilty and save the appeals. She would want to join them. Well, I think that's an interesting point. I think this is maybe my reading the tea leaves, maybe my reading between the lines a little bit. But I think that she still believes that she is a goddess, that she is a member of the 144,000, that she's fighting the death penalty because she has a mission, and that her going to the celestial kingdom now does not mesh with her mission. And so I think that if you asked her, she would say, I can't die because I have a mission to perform. Of course, she also said she was an exalted being who couldn't die. So I think that's an interesting question. I believe that she still believes that this is all a minor inconvenience, that God will deliver her from this tribulation, that she's still going to lead the 144,000, and that the end is coming. And like the Apostle Paul, God is going to send an earthquake that is going to knock down the prison walls, and she's going to walk free. So I think that she is still firmly enmeshed in that religious delusion. So remember the special prosecutor they hired. What the hell has she been doing? Nikki Fife, that is an excellent question. What she hasn't been doing is advising them on how to manage all this discovery. I think she let them down in that regard, and I agree completely. Rachel Smith came from, has practiced in Missouri, I think. She is a prosecution expert. She works for a consulting company that has been hired by the defense to do their public relations stuff. So I wonder whether or not that's a bit of a conflict, but I don't know what she has been doing, but they have been paying her somewhere around $8,000 a month to do whatever she's doing. They pay her travel and her per diem and her lodging, and pay her a salary to advise them on the case. And the last I heard, she was getting paid somewhere around $6,000 a month plus all of her expenses. So your guess is as good as mine. It'll be interesting to see how involved she is at trial. Hi, Beth. Haven't heard from you in a while. Does the defense have an obligation to do their own research without depending on the prosecution for all evidence? So this is an interesting question, because here's the way it works. Law enforcement turns over all discovery, all information about their investigation to the prosecution. There is no mechanism for John Pryor to go to Redmond or Rexburg PD and say, give me all the records about the Daybell case. He can't do that. Everything has to go through the prosecutor. Same with the crime lab. Jim Archibald can't call up the crime lab and say, hey, can you get me that report on that DNA? It has to come through the prosecutor's office. So they're the gatekeeper. The fact that they're the gatekeeper means they have a heightened responsibility to make sure that all of that discovery is provided. That's why we have the Brady rule, a federal rule that requires the release of discovery, because he's limited as to what he can do. Now, if he gets that information, he could take it and have it looked at by a different expert. For example, John Pryor is having all of that raw DNA data looked at by his own DNA expert, but he cannot go directly to the crime lab and say, hey, get me that report and all that raw data so I can have my expert look at it. Unfortunately, that's not the way it works. So that's why the prosecution has this heightened responsibility to make sure that everything is released. Hi, Susie Hutchinson. Will there be a reserved seat for John Pryor, or will he have to hope for a seat like everyone else? I suspect he'll get a reserved seat, and somebody from his office, I'm sure, will be there every day at trial, because they absolutely are going to want to know what happened in that trial. So I think it will. He will have a dedicated seat, I'm sure. Hannah McCullough. Question. It seems weird to me that the prosecution would have a doctor on call that has not examined her. Could they not have compelled her to be examined by one of their experts somehow? It varies from state to state. In some states, the defense can ask the court to order that the defendant be examined by their own independent expert. My understanding of the way Idaho works is that there is a slate of qualified evaluators, and that the court selects one of those people off that slate of evaluators, and the evaluations are completed by that state expert. It gets more difficult when the defense is asking for a private expert to be able to interview and examine their client. And no matter what the court orders, you still get to the position of you still get to the question of whether or not Lori will actually cooperate. So it's a good question. It sort of varies from state to state, but my understanding in Idaho is that the judge doesn't really have the authority to order her to cooperate with an independent evaluation. And particularly with someone like Dr. Wellner, who kind of has a clear, I won't say agenda, but he has a clear area of expertise and interest. Hello, Hazelnut. Thank you so much for the donation. I've seen a lot of donations come by tonight. Haven't had the opportunity to thank all of you individually, but thank you so much, because I appreciate being able to pass those blessings on to our moderators. Hey, Miss Lori, did you hear Judge Boyce stop mid-sentence during today's hearing and say someone's pointing their cell phone at me, and he asked the bailiff to go right over and check it out? Yes, I heard that. I think Judge Boyce is a little bit too sensitive about cell phones, frankly. However, I mean, he was concerned that somebody was violating his order. I mean, it appeared that the bailiff assured the judge that nobody was filming him, and so he went on with the hearing. It didn't sound like the bailiff was found that the person was doing anything untoward. But I mean, it's getting a little bit ridiculous. And let's remember, this is the year 2022 and not 1950. So 2023, thank you, and not 1950. But it's his courtroom. He gets to call those shots. Hello, KCL. Will Chad Daybell get to watch Lori's trial? And surely John Pryor will be watching as well. John Pryor would be absolutely foolish if he's not. I'm certain that if he is not in the courtroom, he is certainly listening to the audio every day. As far as Chad goes, I don't believe he'll have access to it. I'm sure that John Pryor will have parts of it that he will want to play for Chad in the audio. But there's no way he would get to watch Lori's trial. He won't be transported to the Madison County courthouse to watch the trial, I don't believe. I've heard nothing to indicate that he would be. And that would be the only way he would be able to watch it, would be for them to take him every day over to the Madison County courthouse and then sit with him. It takes at least 2 deputies to transport him and to be present at all times with him. So I have my doubts. I think probably what will happen is that John Pryor will play at least parts of the audio for him that seem relevant to his trial coming up. And I'm sure that John Pryor will be in attendance, if not, and if not, he'll be listening. Nicole, did we ever find out what happened in the closed hearings motions when Pryor had an issue with Wood and Company and we suspected something unconstitutional in the old boys club was in play? Nope, because that's the part that Judge Boyce didn't unseal when I filed the motions. So the part of that, I am dead set on getting to the bottom of that, and I very much would like to do that. But I can't do that until the trial's over, and it's possible that he may keep things sealed until Chad Daybell's trial's over. I guarantee that as soon as there is a verdict, I will be filing my motions to unseal all of those documents and all my Freedom of Information Act requests. They are prepared and in a file, just waiting to be able to push send on them. So I'm definitely going to be pursuing that, including getting all of the discovery materials from the prosecution, getting all of the information from the court records. So your girl's on it, to quote Gigi. Question, can Chad listen to the trial on audio on his tablet, even if it's delayed a day? I think that's possible. I think it's possible that he may be able to access the feed and be able to listen to it after the fact, just like the rest of us, unfortunately. And I have to say that if I were Chad's lawyer, I would think it would be important for him to be hearing the co-defendant's trial, and I certainly would be pushing to get that that information. Hi, Victoria. Question: Chad had over 3,000 phone calls. Does Lori have that much? I don't know. We have to remember that Chad is getting phone calls from all of his family members, his kids, his parents. It's my understanding that his parents visit frequently and that they talk to him frequently. I don't know how much contact Lori's family's having with her. We do know that Lori's mother and her sister Summer talk. We have information that they have talked frequently in the past. We have to assume that's continuing. So she may have that many. I think that I think that 3,000 number may be total between the two of them, but I really don't know for sure. We do know that Archibald said in court today that Lori has asked frequently, what did Chad say about these things? What does Chad think? And they were never able to answer that question because they didn't have any of these recordings where he might have indicated what he was thinking. Oh, squeaky wheel. Question, does Judge Boyce still have a black and white TV in his living room and run his computers on Windows 3.1? Well, I honestly don't know. I think it might be possible. I know that he is he's very clearly come down on the side of limiting access and less technology being more. He does not like cell phones in his courtroom. If your cell phone goes off, you hand it to the bailiff. So it's every judge is different. I mean, I appeared in front of a judge that was an old, cranky old guy. He was the best judge ever. I would have appeared in front of him every day. He was a great judge, smart and thorough and wise, but he had his quirks. He couldn't stand it if you wore reader glasses and you put them on top of your head. He would just lose his mind if you stuck your glasses on top of your head. So judges are human beings and they all have their own little quirks. And this judge is not a big fan of technology in his courtroom. So I don't know what to tell you, but right now the Idaho legislature has given him complete control over what happens in his courtroom when it comes to publicity of any type. So. Wow, these 2-hour sessions, I get tired. Gail Swift Fernandez, we're all of Lori's phone. Remember Tylee said she had so many phones, she looked like a drug dealer. Yeah, as far as we know, law enforcement has all those phones. And in fact, if you happen to tune into Pretty Lies and Alibis and their deep dives into the Arizona documents, you can see that there are text messages that come from different phones and different phone numbers, and that Lori at one point had a phone that was only dedicated to Chad. She had a phone that she only talked to her other followers on, one for her kids. So yeah, and I'm sure they have all those phones because they were all identified. For one thing, they were all connected to Lori's iCloud account. And so a lot of that information was available because they downloaded it out of her iCloud account. I'm not a tech person, so I don't quite understand how all that works, but I know that if you have Apple devices, everything gets connected in your iCloud. So I'm sure they have all that and lots of other as well. So they get unlimited phone calls in jail. That's just wrong. No, they don't get unlimited phone calls. There is a phone system. First of all, they have to be, the person calling them or the person they're calling has to be on their contact list, has to be approved by the jail, has to be related in some way. And then they pay for their phone access. So they can make collect calls to the person that they're calling. And if that person accepts the collect call, then the person on the other end is paying for it. They also have people put money on their books so that they can make Telmate video calls. So there is a private contractor who contracts to put video kiosks in jails, and the inmate, the video kiosk is connected electronically to their canteen account, their money account. And so people can put money on their books, and then they can use that money to make those Telmate kiosk calls. So there's two ways that they can make phone calls with the outside. But they're not unlimited, and they're limited by how much people are willing to pay or how much the defendant can pay for. They're limited usually in the length of time and the times at which they can make those phone calls. They do have unlimited contact with their attorneys. It always made me laugh because I had a couple of clients, one in particular, who used to call my office every day, and he would talk to my assistant. He was in segregation, so he didn't have a lot of contact with the outside world, and he would call every day and ask my assistant, "What's the weather like outside?" And he was just lonely and bored, and yeah. So they do have a lot of access. 575 in chat tonight. That's amazing. Thank you so much for being with us and being with us to talk about all of these issues in the run up to the Vallow case. So that's super exciting. I think we have time for a couple more questions before we wrap it up. Once again, I want to say thank you. I have seen a number of very generous super chats go by, and I want to thank you for blessing me so that I can bless my mods, because it makes a big difference for them, and I appreciate you giving me the opportunity to do that for them. Catlink question: could the no camera order for Lori's trial be to limit tainting the jury pool for Chad? That's the only theory I've heard that has a lick of logic. Well, I don't disagree with that. And it may be that the judge just feels like, out of an abundance of caution, he doesn't want to run the risk of tainting a future jury for Chad. Let's remember, though, people have kind of short memories. We're all a little bit like goldfish, we have 3-second memories. And they're talking about Chad's trial. John Pryor's asking that Chad's trial not be set until next spring. I think the prosecution's going to be asking that the case be set in the fall, late fall, maybe. But nonetheless, I think people have kind of short memories and short attention spans. And the next thing is going to come along and people are going to be interested in it. So I'm not quite as worried about whether or not the jury pool is tainted for Chad, but it may be a factor in the judge deciding not to allow the live stream for the trial. You're right. Could Judge Boyce restrict documents from Lori's trial that might affect Chad's? It's a possibility. I think it's going to be, I think it's a possibility. I think it's going to be difficult because once those documents come into evidence, they're public record. So I think it's going to be hard for him to keep that record sealed beyond Lori's trial. I mean, I think there could be an argument. I get what you're saying, Kathleen. I think there could be an argument that that the judge wants to hold back some things or restrict access because it might prejudice Chad's trial. But I mean, I think there's an argument to be made that that is the consequence of severing the case. Chad wanted more time. Chad wanted the case severed. So the consequence of that is Lori's case goes first. There's a lot of benefit for Chad in him being able to see the state's evidence and to hear the state's theory of the case. And there's a lot of benefit for that to him. There could be some downsides to it too. There could be the consequence that there's some taint to the jury pool. But I think that I think that it is still possible to seat an unbiased jury, even if those documents get released, and I'm going to be fighting like holy hell to get them released. So I think it would be really difficult for them to continue to restrict access to the discovery materials, saying that they're trying to protect Chad's case. I mean, that's the consequence of severing the cases. Who made the decision not to include mental health, Lori or the defense attorneys? Without a doubt, it was Lori. Without a doubt. I mean, all you have to do is hear Jim Archibald talk for 30 seconds, and you know that if it were up to him, he would be putting on a mental disease or defect defense. I think Jim Archibald believes in his heart of hearts that Lori is mentally ill, and that she is mentally ill to the level where there's a question about whether or not she's culpable. Remember, in Idaho, the only way you get there is to be able to say, my client was so mentally ill, she couldn't form the mental state to knowingly or intentionally commit the crime. So, you know, I think that's always an uphill battle, but if you listen for any time to Jim Archibald, you will see that he is deeply concerned that Lori is going to trial, and that we are going to convict and potentially put to death a mentally ill woman. I will say, I think that Jim Archibald is a true committed public defender. He doesn't like the death penalty. He doesn't want to see anyone get the death penalty. He is philosophically and fundamentally opposed, and that's where he comes down. And that's what you want in a death penalty defense attorney. And I think that he's fighting tooth and nail. If it were up to him, Lori would have waived her speedy trial, and they would be making a serious mental disease or defect argument. And I'm sure he's really frustrated about that. But we as defense attorneys, we as attorneys know that we have an obligation to follow the direction of our clients, even when we don't agree, even when we disagree with the strategy and the way that they want us to proceed in the case. We're obligated because it's their constitutional rights, not ours. The rights are invested in them and their individual humanity. And we don't get to make that decision for them, even if we disagree, and even if we can make a great argument for all the reasons why they should follow our advice. Ultimately, the client makes the decision, and she has decided that's not how she wants to proceed. Who knows why? I mean, I don't know why, but she certainly does not want that mentally ill label. Well, folks, we've hit the 2-hour mark. I want to say thank you so much for all of you joining us tonight. Thank you for having over 576 people in our chat tonight. Thanks so much for joining us. It means the world to me that you spend your time. We know that time is precious, and it means the world to me that you spend your time with us. I know our chat moves quick and that I don't always get to all the questions. So, especially if you're new to the channel, I want you to hear this. Please post your questions in the comments down below, because I get up every morning on Thursday mornings and on Saturday mornings and drink my coffee and review all your posts. I review the chat, and I also answer emails. My email's down in the show description, along with a lot of other really interesting information. So check in there. And if you don't feel comfortable posting your question in our chat or in our comments section, email me directly, because I answer those emails and I answer questions. Thanks, everyone. I do want to say I get so many compliments and so many great comments about our followers. that they are classy, that you are all interesting without being hostile, that you're that everybody's got great opinions and respects one another. And that doesn't just happen. It happens because I try to give you the best information I can without being super inflammatory, although I do get on my soapbox every once in a while. And our mods do their best to make sure that we're staying civil in the chat. And I just want to tell you how much I appreciate that, because it is not the norm. We don't see that in everybody's chat. And people who come to our show and to our chat are amazed at you all. So thank you so much for being the kind of community that that we all want to be a part of. So I'm going to say goodnight. Thanks again to my mods. Thanks for joining us. And we will see you Friday, when we will dive even deeper, if that's possible, into Vallow-Daybell and into getting ready for the trial. I'm also going to have some information that you might be interested in if you happen to be in the Boise local area. So be sure and tune in on Friday, and we'll have some announcements to make. I'm going to say goodnight to you all. Have a great couple of days, and I'll see you on Friday.